All right, I call this meeting of the Judiciary, Finance, and Civil Law Committee to order. We are holding this meeting remotely under House Rule 10.01. We will start with the roll. Anna, please go ahead.
Chair Becker-Finn.
Present.
Representative Mueller.
Present.
Representative Scott. Representative Feist.
Present.
Representative Frazier.
Present.
Representative Grossel.
Present.
Representative Herr. Representative Hollins.
Present.
Representative Johnson.
Present.
Representative Liebling.
Present.
Representative Long.
Present.
Representative Mortensen.
Present. Present.
Representative Novotny.
Present.
Representative Farr.
Present.
Representative Robbins. Representative Vang.
Present.
Representative Zhang.
Present.
All right, a quorum is present. First order of business will be to move the minutes from March 25th. Representative Vang, would you move the minutes of March 25th, 2021?
So moved, Madam Chair.
Thank you. Representative Vang moves the minutes. Members, any discussion to the minutes? All those in favor, please say aye.
Aye.
Aye. Aye.
Opposed? All right, the minutes are approved for March 25th, 2021. Members, we've got two bills up today. The first bill on our agenda is House File 1691. This is a Representative Hornstein bill. Representative Hornstein, I will move your bill. So I will move that House File 1691 be recommended to be re-referred to Ways and Means. Representative Hornstein, your bill is now before us. Please tell us about your bill.
Thank you so much for hearing the bill, Madam Chair and committee members. And I'm going to be co-presenting this bill with Representative Vang. So I'll say a few opening comments and then hand it over to Representative Vang. Members, I know some of you heard this bill on Tuesday, so you're familiar with it. But for others, I just wanted to give a little bit of background as to why this bill is before us, why a diverse coalition worked on this for a number of years to get it in the shape it's in. House File 1691 addresses an issue concerning the underreporting of hate crimes. It closes a few loopholes in existing hate crimes law and assists in the development of new curricula for law enforcement as it relates to the reporting of hate crimes. And I just came across an article. I didn't mention this in the earlier hearing, but I came across this just a couple days ago, and I thought it's very compelling. So I'm going to quote from it, Madam Chair and members. It's from Police Chief Magazine or a newsletter. I know it's from a trade association of national police chiefs. And in this article, it talks about that it mentions the fact that hate crimes are overwhelmingly underreported, both by victims and law enforcement officers. And they write, despite the fact that these hate crimes are largely unacknowledged, and as well as their associated problems, fear, social unrest, alienation, these are occurring at an alarming rate. And what's more, the very fact that hate crimes are underreported not only encourages such incidents, but also poisons relations between law enforcement and the communities they serve. And they list four, and I'll conclude with this, Madam Chair, in terms of this article, 4 compelling reasons to seek accurate reporting of hate crimes. Hate crimes are overwhelmingly violent and often vicious, more vicious than other assaults. They affect entire communities, not just the victims. Underreporting of hate crimes spreads fear and distrust. Reporting hate crimes can lead to their prevention by identifying those prone to these activities and sending a message that these crimes will not be ignored. And so I wanted to point that out because many of us are familiar with the very heinous crimes that seem to make the media. And I think our coalition, the coalition I'm working with, was formed shortly after there was a bombing at the Dar al-Farouk Mosque in Bloomington in 2017. And of course, that came on the heels of a very disturbing incident at an Applebee's in Coon Rapids, where a Somali immigrant, Asma Jama, was hit over the head with a beer stein. Shortly after Dar al-Farouk, we had the massacre in Pittsburgh, 11 Jewish worshipers killed while worshiping at Sabbath services. Following that, we had numerous reports of a rise in hate crimes among transgender women of color. 44 trans women of color killed across the United States just last year alone. And then, of course, the disturbing events this year. With Asian Americans targeted as a result of COVID. We had the murder of George Floyd, which led to a racial reckoning and much more attention paid to hate crimes. And then most recently, the Capitol insurrection, where some of those that were perpetrating that crime had strong links to violent extremist groups that promote various racist, anti-Semitic, and xenophobic, Islamophobic ideologies. So those are the things that are often in the news, but there's much more under the surface. 1/3 of these crimes are underreported. So quickly, Madam Chair, to the bill, there are 3 key elements. One is to address the issue of underreporting. We have a mechanism set up where community groups, in addition to law enforcement, can report hate crimes to the Department of Human Rights. We believe, and the communities that helped write this bill believe strongly, that this will address one of the issues related to underreporting, which is that those victims of hate crimes are far more likely to discuss the incident with a community organization that they know and trust. So that is a key element of this bill. Secondly, we work with the Post Board to update the hate crimes and bias manual. That has not been updated in 30 years. And for the reasons I mentioned, Madam Chair, it does need some updating. So there is some work that will be done on the curricula. We're not asking the Post Board to add additional training, but to update the training manual. Others have been, they're not themselves, what I meant is they're not themselves doing the training, but they will review the updated curricula with the Department of Human Rights. And of course, there's many other groups that do such training, very reputable groups that the Post Board currently works with and can continue to work with on updated training, which we think will be very helpful. And then finally, we saw a number of crimes related to property desecration, graffiti incidents, and others that sometimes are not considered hate crimes, even though, for example, in the district I represent, we had a Nazi graffiti sprayed on a school, and that clearly is something that is very jarring to the community and should be considered and classified as a hate crime. So with that, I wanted to call on Representative Vang, who I have talked with, and we have worked together on this issue for a number of years. And I wanted her to give her perspective on the legislation.
Thank you, Representative Hornstein. Representative Vang.
Thank you, Madam Chair, and thank you, Representative Hornstein, for bringing forward this important bill. I just want to take the committee back to March of 2020 when the pandemic started. The first phase of anti-Asian sentiment started in the Asian stores. A year ago, while we were dealing with issues of price gouging in stores with empty shelves, running out of toilet paper and hand sanitizers, the Asian stores were left untouched, full in stock because they were deemed unclean and were associated with where the virus is coming from. The turning point of anti-Asian hate came from our former President Trump, who called it the Chinese virus, further exacerbating the stigma of the Asian community of what we're already dealing with. From then on, we saw numerous social media stories of Asian elders getting attacked at the parks, Asian Americans verbally harassed in the parking lots. We even had a viral video of 3 teens kicking an Asian woman while she was waiting at the light rail stop here in St. Paul. So even while all this is happening, the state did not have the infrastructure to capture what is happening to our community. We had to scramble to set up a hotline and reporting depository to capture all the hate and bias incidents and crime with the Minnesota Department of Human Rights. And I'm grateful for the leadership of Commissioner Lucero for prioritizing that work. To date, nearly 10% of all COVID-19 related calls to them were bias and hate related incidents. And I know for sure that is an understatement and definitely underreported. This bill can help improve how hate and discrimination is reported and shed light to the realities our communities are experiencing. We still have a lot of work to do to address hate, and most particularly right now, anti-Asian hate. We must take action against hate, and we can't allow for it to continue, because we have seen what it looks like last Tuesday in Atlanta, where 8 people have died. 2 weeks ago in Atlanta, where 8 people have died as a result, 6 of whom are Asian women. So once again, thank you, Representative Hornstein, and I yield my time.
Thank you, Representative Vang. We will move on to the testifiers. We have a couple people on the list. First on the list is Nick Kaur. If you could introduce yourself and then go ahead with your testimony.
Hello, my name is Nick Kaur. I use he, him, his pronouns. I'm the Senior Manager of Movement Building at CAL, the Coalition of Asian American Leaders. Thank you, Madam Chair and members of the committee. Thank you, Representative Hornstein and Representative Vang. I'm speaking to you all today a little over a week after the devastating murders in Atlanta, where a shooter targeted 3 Asian-owned businesses and killed 8 people, 6 of whom were Asian women. Unfortunately, this act of hate does not stand alone and fits with a pattern that we've seen before in history. And here in Minnesota, just as in other parts of the United States, we have seen an increase in attacks and violence directed towards Asian American communities. The latest data shows that nearly 4,000 reported incidents of anti-Asian violence occurred nationwide, with women representing 60% of the cases. Here in Minnesota, we have seen physical and verbal abuse on the streets, in stores, and other public places. And just a week ago in St. Paul, a group of Asian parents and students here also experienced hatred when a driver came up to them and told them to leave this country or they would be killed. We have seen intimidation, as with the case of a young couple in Woodbury who came home to a note left on their door telling them to take the virus and go home. In Austin, Minnesota, where the words China virus were burned on a family's front lawn. And also, unfortunately, our children have not been immune to this either, and they've seen continued anti-Asian harassment and discrimination in schools. We support this bill because it closes loopholes in our hate crimes laws, and importantly, it provides support to victims of hate, and it allows us as community organizations to be co-responders to hate. As a trusted community organization, people are choosing to come to us rather than the police or other government entities, and they come to us because they want to be heard and they want to be supported. And unfortunately, right now, we just don't have the support to play that role. And often what communities report to us is discounted. And so right now, our communities are scared and worried, and they're asking for our help. And so we are asking for your help. What happened in Atlanta does not have to happen, and we have a chance to make sure it doesn't happen again. Everyone should feel like they can walk on the street without fear of being targeted or attacked. Our communities are in pain. We are hurting. We are scared, and we're looking to our elected leaders to take action right now. And so right now we ask for your support, and we urge you to pass this bill. Thank you.
Thank you, Mr. Kaur. Next on the list is Zainab Abdi. If you could introduce yourself and then go ahead with your testimony.
Thank you very much. Good morning and salam, everyone. My name is Zainab Abdi, and I am the Civic Engagement Coordinator at the Reviving Islamic Sisterhood for Empowerment, also known as RISE. Thank you, Madam Chair and committee members, and thank you, Representative Hornstein and Representative Vang. I'm here to support this bill. I identify as a Black, Middle Eastern, West Asian immigrant Muslim woman. With the intersectionality of my diverse identity comes fear of being attacked and assaulted due to the hate crimes based on what I look like and what I wear. For decades, the Muslim community in Minnesota has experienced Islamophobia, but since 2016, hate crimes against Muslims has been on the rise. White supremacist rhetoric has led to lost lives, broken communities, and sacred spaces like our mosque being bombed and attacked. Muslim women are more frequently targeted in Islamophobic hate crimes, especially Muslim women who wear the hijab like me. Reported data shows that nearly 70% of hate crimes against Muslim women against Muslims are against Muslim women. And often gender Islamophobia goes underreported and unreported as well. Those who survive these assaults have little to no support from the state when they deserve at the minimum compensation for lost work, lost time with loved one, and the trauma that they have been experiencing. It's time for our legislators and states to listen to the voices of marginalized communities and take action to pass this bill. Our safety should not depend on our fate, the color of our skin, or any of our other identities. We call on our lawmakers to stop hate in Minnesota by passing this community-led peace legislation. Thank you so much for giving me the space to testify.
Thank you very much. And we have a third testifier, Karen Maratz, if you could introduce yourself and go ahead with your testimony.
Thank you, Chair. My name is Karen Maratz. I'm the Executive Director of Jewish Community Action, and we're part of the Communities Combating Hate Coalition. I'm happy to join you to speak in support of House File 1691. I want to speak about our coalition. The Communities Combating Hate Coalition is a group of faith-based, immigrant-led, LGBTQ, and gender advocacy organizations. We know that hate has been rising across the country and here in Minnesota. We know because it's been our experience. Our communities have been targeted by violence and intimidation, and often our organizations and our staff play dual roles. So we as individuals have been targeted, and then as part of organizations, we often as staff play the role of comforting others and responding when they've been targeted as well. Our groups often come together following an attack. So I remember the women from RISE, who are also part of our coalition, reaching out immediately after the anti-Semitic Tree of Life synagogue massacre. And likewise, Jewish Community Action has always stood with our Muslim friends following an attack on their community. And we tell each other our stories, and that honesty enables us to support each other. But we want to do more than just comfort and support each other. And this bill represents all of us coming together to offer solutions and a proactive plan to strengthen our state's response and to shape policies that will keep us all safer. The most important piece of House File 1691 for Jewish Community Action is that it establishes a new channel to the state to share those stories through the Department of Human Rights. We know that many of the stories that we hear from our own community, our own members and others, do not result in a report being filed with law enforcement, and therefore they're ultimately never even seen or captured by the state. Some communities don't feel safe talking to law enforcement. In some cases, it's not clear that law enforcement is actually the right place to go to, or that they've been trained to respond. We know from meetings with the Post Board and law enforcement, and as Representative Hornstein said, that their training in this area is pretty out of date. So we know that there are many stories that are going untold or just unheard that never become part of a bigger picture of what's happening in Minnesota. Our communities need support. Our organizations do a lot to respond to hate, from counseling and trauma support to developing real solutions to prevent future attacks. And we want the state of Minnesota involved. We want to help you as leadership build an accurate picture of what's happening so that we can have conversations about how to stop it. So our bill opens a channel for community organizations to share the reports that we're already taking, which will enable leadership to develop that accurate representation of what communities are experiencing in Minnesota and to respond appropriately. I want to say it's been a tremendous honor to work with the other organizations and communities in this coalition. So often, in order to make the case publicly for support, we have to lay ourselves bare and be incredibly vulnerable and share our trauma with and for people who may or may not actually just be on our side. And I just want to thank everyone who's testified now or earlier this week in support of this bill for continuing to do that. And I do also want to say it's been incredibly heartening in the last few days to watch hundreds of letters of support from organizations, community members. This morning, the Ramsey County Commission just come in support of our coalition and this work and our bill. So it's been an honor to speak with you this morning. This is an absolutely crucial moment for us to come together to keep our communities safe. Thank you.
Thank you very much, Ms. Maratz. With that, members, those are the testifiers I have on the list. I note that there are a whole team of folks available to answer questions should their expertise be needed. Members will move on to discussion of the bill. Representative Johnson.
Chair Beckman, Representative Hornstein, I understand the concept of this bill.
In public safety, we talked some issues dealing with the post board. I'm just wondering if you've had a chance to get that amendment drafted to fix those issues, because post board does not write the curriculum. They put in the elements, and usually the trainers write the curriculum and present it to post board for post board or for credits for the officers to get the curriculum approved.
Representative Hornstein.
Thank you, Madam Chair, and Representative Johnson. We did add an amendment clarifying that piece in public safety. So that's in the first engrossment of the bill. And we do have Chief McCarthy available, and she can certainly answer questions about the post board's role in this effort, if that would be helpful.
Yeah, we'll go to Chief McCarthy. If you could introduce yourself for the record and then go ahead with your response.
Thank you, Madam Chair. My name is Kelly McCarthy. I'm the chief of the Mendota Heights Police Department. I'm also the current chair of the Minnesota Peace Officers Standards and Training Board. Like Representative Johnson accurately described, we do not create the content, and I have worked with many of the members on this bill, and we've identified those resources that we will work together with in order to vet the training to ensure that it's timely and accurate.
All right, follow-up, Representative Johnson.
Chair Becker-Finn, Representative Hornstein, those are issues I brought up after the amendment was put on. There were still changes needed to be done to fix that. I hope that we can work on it to get that corrected. I do have some other issues with this bill as well. I'm thinking as more and more I look at this, the reporting is being done by the wrong individuals. It should be the prosecutors doing the reporting, not the officers on scene. The officers on the scene take the initial complaint, do the investigation, do the reports, and send it to the prosecutors for review, the final review. They may charge on the basic stuff to get them into the court system, but the prosecutors go through the reports, look at all the elements, and see which crime should actually be charged, what level of crime. Those are the ones that make the determination what they can do. And I think it should be the prosecutors doing this reporting. Should the officers be trained in looking for this stuff so they can accurately do their reports to get the elements needed? Absolutely. But it's up to the prosecutors to determine those situations. So I think we need to actually go back through on this bill and restart it and get it done properly. Because the officers are not lawyers, they can't look at all the elements. They just do the reports, and it's up to the prosecutors to make sure the elements actually fit the crime. Otherwise, we're going to get bad information. Whether it's getting a report of something that does not qualify with the elements of the crime, or getting things that should be end up being prosecuted for it, but they're not reported because they weren't in the initial part of it. So I think we need to relook at that and how we do this. Do I want crimes of bias stopped? Absolutely. But I also want to do it in the right way.
Thank you, Representative Johnson. I'm actually going to go to one of our prosecutors, Representative Vice Chair Moeller. You are next.
Thank you, Madam Chair, and thank you to Representative Hornstein for bringing this important bill, and to all the testifiers and those who've been working on this legislation. And really, as we just heard from the testifiers, a lot of these crimes motivated by bias, hate crimes, are underreported, and people may not feel comfortable going to law enforcement for a variety of reasons. And so if we just rely on those cases that are moving through the courts, for the reporting, we're not capturing all of the hate crimes that are being committed out there. And so I just wanted to emphasize how important it is that we have other avenues for folks to be able to report these crimes. And I'm really glad that the bill provides for that. Thank you, Madam Chair.
Thank you, Vice Chair Moeller. And I will note, too, that prosecutors are often limited by which cases get sent to them by the police. police officers who are on the ground taking the reports. So I think that's an important element as well. Representative Long.
Thank you so much, Madam Chair, and thank you, Representative Hornstein, for bringing this really important bill forward. And I'll echo Representative Muller's thanks to all of the testifiers and to the really big and diverse coalition that has worked really hard on this. And it's unfortunate that the coalition is so big, but I think it speaks to how many communities are touched by hate crimes and by crimes motivated by bias. And I just wanted to speak to two parts of the bill. First is the property crimes update. I think that's really important. I had the opportunity just a couple of years ago to visit with Representative Zhejiang the damage to the Darul Iman Mosque in his community and the graffiti that had been perpetrated against them, which was clearly religiously motivated, hateful graffiti, and sent a shockwave through the entire mosque. We were there for Friday prayers service, and the entire community was impacted by that graffiti, felt unsafe, felt threatened by it. So it wasn't, just a simple graffiti, right? The crime clearly was a lot more than that. It was the hateful impact of the crime was what resonated in that community and with the mosque members and with really the entire Muslim community in St. Paul and around the state because of that incident. So I think clarifying these definitions is really important. And we know that from the shooting just last week in Atlanta, that hate crimes can affect an entire nation, right? If we have hate crimes in one community that are targeted at a particular set of individuals, that can make people feel unsafe all across the country, all across our communities. And so these are really powerfully harmful crimes. And the second part I'd like to speak to is the underreporting and the importance of relying on community groups. And I was just hoping Chief McCarthy might be willing to speak to what you see as the value of having community groups be involved in the reporting process.
Chief McCarthy.
Thank you, Madam Chair. Yes, sir. This is one of those rare pieces of legislation that acknowledges that we have a system-wide problem and then instills a system-wide fix. So there are many communities who either don't feel comfortable or safe reporting to the police for many reasons, and not necessarily the fault of the police or the fault of the victim. What this does is it enables us to get accurate data. And nobody wants to have a hate crime in their community, but the only thing worse than having a hate crime in your community is having one and not knowing about it. So what this will do is actually give police the information that we need to help address these very serious crimes.
Thank you.
Thank you, Chief McCarthy. Any follow-up, Representative Long?
No, thank you.
All right, thank you, Representative Long. Representative Feist.
Thank you, Madam Chair. I just wanted to thank Representative Hornstein for bringing this important bill and for engaging with me behind the scenes. I'm a former board member of the ACLU of Minnesota, so I just always have civil liberties on the brain. And I just wanted to talk with him to make sure that we don't have unintended consequences, that we make sure that this language is as precise as it needs to be. And I just wanted to thank him. That's all I wanted to say. Thank you.
All right. Thank you, Representative Feist. Representative Johnson, and then we're going to move to the closing and the vote.
Chair Becker-Finn, I was not had not finished when you sent it off to other people. There's not a problem with the other people reporting to the Department of Human Rights, but I also want to make sure that they're properly investigated and looked at to make sure they actually do fit the elements. The issue in Atlanta was brought up, actually doing the reports and the statements from the suspect in that incident. It was not he did not target it because of the nationality. He targeted the actual business because the person was having issues dealing with pornography. Nothing about the nationality. There are six Eastern Asian people that were killed, was two Caucasian people. It was nothing to do with race. It was an issue with pornography and having a mental health issue. We want to get the record straight here.
Representative Johnson. I know you heard me the first time. I'm just going to caution you to not make assumptions based on what the suspects in a crime state about their motivations. Is, you know, if we take the word of suspects in every crime that occurs, I think we won't be in a good spot. So I just want to make sure we're being careful about the assumptions we're making.
I will stop at that one, but then I'm going to go to Boulder, Colorado, where the press, you don't hear anything about that anymore because it didn't fit the narrative. The person that's actually doing it was a Somali American, born in Somalia and came here. It didn't fit the narrative that's being pushed. Originally it was a hate crime or a white supremacy issue until they found out who the person was. We have to look at all the facts, and we want to make sure that the information is gathered is correct. And we want to make sure that these kinds of bias are right. Now, if you go to the National Crime Victims survey done by the Department of Statistics, or Office of, by the federal government, that has a very good record. Well over at least 50% of crimes, not just bias crimes, but all crimes are unreported. It's a very good report. It was very fascinating reading through it and going through it. I think everybody on this committee and public safety should actually take a good dive into that report. I found it reading a Wall Street Journal article, and it's very fascinating. And very enlightening on what's actually going on across this, not only the state of Minnesota, but across the country. Do I want these crimes of bias to continue? Absolutely not. But I do believe this bill is written improperly to get a true and accurate picture of what's going on. Training is important for the officers to know what they're looking at, but the proper training as well. There's some issues with this bill that unfortunately I cannot support.
Thank you. I do want to correct for the record, as we talk about narratives, that the suspect in the incident in Boulder was not Somali. And I think it's important that we're careful about stating things like that without being certain. Representative Frazier.
Thank you, Madam Chair. Thank you for that clarification. I was going to clarify that point. I do think the record should be straight, and that was a specific racial profile, but making an inaccurate point that Representative Johnson made. But just also, the individual in Atlanta, he chose those businesses because they were owned by Asians. He went into those businesses. He killed individuals that he was not even sure if they worked in those businesses, but they were Asian, so he killed them. We have to stop painting these false narratives just because someone says, I'm not racist. It wasn't racially motivated. We don't take their word for it. I was a criminal defense attorney. All of my clients were innocent. So we have to stop painting these false narratives, and we have to let things play out. We always talk about looking at the facts and letting the investigations play out, but then we come in here and we paint these false narratives, and we want to provide alternative facts that we do not know. So I just want to make sure that we are clear for the record, because people are watching us, and we should be fact-based in these committee meetings. Thank you.
Thank you very much, Representative Frazier. And with that, Representative Hornstein and Representative Vang, I will go to you for the closing.
Chair Becker-Finn, I will correct myself. He was from Syria.
Representative Johnson, you have to wait to be recognized. That's how the rules of committee work. Representative Hornstein and Representative Vang, to your closing.
Well, thank you very much, Madam Chair. Thank you, members, for a very good conversation. Representative Johnson, I think that the issue of prosecutors is important. I know that we've had conversations with the Attorney General on this bill and his office, as well as some county level prosecutors. The Attorney General's office has vetted this bill as well and are in support. But I do think that, raising those voices are important. And we will continue to do so. So I want to just thank you, Madam Chair, for your interest in hearing this bill. As a strong advocate of human rights, I appreciate your allyship. And I This is an important bill. There are some things that perhaps could be, some items that we could take a look at as it moves through the process. But we do believe this is a very unique and actually could provide a national model for increasing the reporting of hate crimes. 1/3 of which, 2/3 of which are underreported. So this fills a very important void, and I appreciate again the good conversation from the committee and ask for your support.
Representative Vang, any closing comments?
Thank you, Madam Chair. I just want to thank the committee members and Representative Hornstein for bringing forward this bill and for everyone's support. What happened in Atlanta is definitely a racially motivated attack. If we don't call it out for what it is, we're going to see more of that coming, because we have let a whole year go by not naming what's happening to our community, what it is. And when Atlanta happened, we should have seen that coming. And so we must call it for what it is. We must be the leaders to say that that is not okay. And so I hope that members will continue to, not only just rally around sensational events, but continue to call out hate when we see it. Thank you.
Thank you, Representative Vang. With that, there were no amendments filed, so I will renew my motion that House File 1691 be recommended to be re-referred to the Ways and Means Committee. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott. Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossel.
No.
Representative Hurd.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
No.
Representative Liebling.
Aye.
Representative Long.
Aye.
Representative Mortensen.
No.
Representative Novotny.
Aye.
Representative Farr.
No.
Representative Robbins.
No.
Representative Vang.
Aye.
Representative Zhang.
Aye.
There are 11 ayes and 5 nays.
All right, with 11 ayes and 5 nays, the motion prevails and House File 1691 is recommended to be re-referred to Ways and Means. Thank you very much, Representative Hornstein and Representative Vang, for bringing this bill forward. And for those on the call who this applies to, I wish you a happy Passover week and hope that everyone gets a good break in the coming days. So thank you for bringing your bill up today.
Thank you, Madam Chair, and thank you, members.
Right, thank you. With that, we'll move on to our second and last bill today, which is House File 1761. This is a Representative Hollins bill. Representative Hollins, would you like to move your bill to be recommended to be placed on the general register?
Yes, Madam Chair, thank you. That is my motion.
All right, thank you, Representative Hollins. Your bill is now before us. Please tell us about your bill.
Thank you, Madam Chair, and thank you, members of the committee. This bill was written with the belief and understanding that we can come to a bipartisan solution to reduce the carceral state while still maintaining public safety and security. In recent years, both Republicans and Democrats nationwide have united around criminal justice reforms related to probation. There's a number of reasons why. Mostly related to the cost, but also relating to the fact that probation allows offenders to keep their jobs and earn income and become participatory members of society. But as I mentioned, it is also significantly cheaper than incarceration. If people commit a crime, they should absolutely be held accountable. But often people under probation supervision are incarcerated for non-criminal technical violations, like not contacting their probation agents or having a dirty UA. Though the data regarding technical violations isn't complete and it's difficult to collect, this bill takes a step towards ensuring that people in probation are not sent to prison for their first technical violation. This bill was proposed by the Minnesota Association of Community Corrections Act Counties, or MACAC, to provide assurance that the policies CCA jurisdictions have in place are being followed and that revocation is not an available sanction for a single violation of the enumerated conditions list. The bill is intended to strike a balance between providing responsive probation tailored to the risk and need of an individual client and ensuring that the court holds probation agencies accountable for following evidence-based practices by not approving revocation requests for a single technical violation. We believe that the correctional treatment is better provided through community resources than through confinement. So in situations where someone on probation has violated one of the enumerated provisions, which does not present a public safety risk, a probation officer cannot automatically execute a sentence or take them into custody. These violations include alcohol use, drug use, curfew violations, failure to report to a probation agent, and any crime that would be a petty misdemeanor, like a traffic violation. In order to execute a sentence for the first instance, one of these violations, the court must receive a written report showing probable cause to believe the person violated probation and establishing by a preponderance of the evidence that the continued presence of the person in the community would present a risk to public safety. If a probation agent cannot state why they reasonably believe the person is a risk to public safety while remaining in the community, they will have an opportunity to consider alternative sanctions. I have two testifiers to speak to this bill today. I don't know if you want me to introduce them, Chair Becker-Finn, or if you would prefer to introduce them.
And Representative Hollins and members, Chair Becker-Finn had to step away for a minute. So I've got the gavel right now. And I can go ahead. I've got the list here of the testifiers. And so, and I believe your first testifier is Catherine Johnson.
That's correct.
All right. Welcome to the committee, Ms. Johnson. And if you can please introduce yourself and begin.
Thank you very much, Madam Chair and committee members. My name is Catherine Johnson, and I am the Legislative Committee co-chair for the Minnesota Association of Community Corrections Act Counties, and also the director of Hennepin County Department of Community Corrections and Rehabilitation. I am here today on behalf of MACAC. The Minnesota Association of Community Corrections Act Counties represents the 34 Minnesota counties that have chosen to provide probation and supervised release services under the Community Corrections Act. MACAC counties provide community supervision to more than 70% of people on probation or supervised release in Minnesota. I want to begin today by thanking Representative Hollins for her work on this bill and her commitment to creating a policy that balances public safety and rehabilitation. Over the last 10 years, probation practice in Minnesota and nationally has changed dramatically. While no system is perfect, community corrections professionals across all three delivery systems in Minnesota strive to provide support and services for our clients through the use of evidence-based practices. While we certainly have a role in enforcing court conditions, our purpose and our goal is to provide rehabilitative services and targeted interventions that reduce recidivism and support clients in a way that prevents future involvement in the justice system and improves community safety. Our agents work with clients to help them achieve success by assessing underlying reasons for their justice system involvement, facilitating access to resources to address those issues, including transportation, housing, employment, education, and treatment, and supporting clients' efforts at behavior change. Most clients move through the supervision process without violations. Others do not. For those who struggle, our agents try to file a formal violation report as a last resort. There are often many sanctions conferences or violations of probation prior to any request to the court for a revocation of a stay of sentence. That said, we also recognize this is not always the case. We understand that probation agents are not perfect and are subject to the same stresses as other criminal justice professionals. This bill would provide an additional way to ensure that minor violations that do not have significant public safety implications are not a reason to revoke a stay or send a client to prison as a first step. It requires stricter review by judges of recommendations from probation to ensure that those recommendations are consistent with evidence-based practices. It also allows our agents to use discretion in instances that do pose a significant risk to public safety. One example might be domestic abuse that is tied directly to substance abuse. Treatment is always the best option, but there needs to be safeguards for victim safety in the event of relapse by the client. We know that for some, this bill does not go far enough, and for others, it goes too far. We recognize that it isn't perfect, but we hope to continue to work on the language with Representative Hollins and other stakeholders as this bill continues through the legislative process. I want to say that with me today is Midge Christensen, who is also co-chair of the MACAC Legislative Committee and the director of 6W Community Corrections in West Central Minnesota. I want to say thank you for your time today and let you know that both myself and Ms. Christensen will remain on the call for questions. Thank you very much.
Thank you so much. And I believe your next testifier is Will Cooley. And so welcome to the committee, Mr. Cooley. Please introduce yourself and you can begin.
Thank you, Vice Chair Moeller. My name is Will Cooley, and I'm a member of the Decarcerate Minnesota Coalition. When we talk to folks about technical violations, we often get a puzzled look. But revocations for non-crimes are a major cause of criminal justice dysfunction and undermine the system's legitimacy. In 2017, 65% of prison admissions in Minnesota were for supervision violations. These violators are often warehoused for a short time and then re-released without having underlying issues addressed. The Department of Corrections' own research shows that warehousing is criminogenic. Long periods of incarceration for non-crimes can cause people to lose their jobs, homes, and even custody of their children. The effort to reform technical violations came from the grassroots. Incarcerated and formerly incarcerated people put this issue at the top of our agenda. And to help craft these reforms, we have engaged stakeholders across the state, including DOC officials, prison guards, supervision agents, judges, and prosecutors. For example, we reached out to the Violence Free Minnesota Coalition. They're involved in ending relationship abuse. In a survey of their membership, 82% supported technical violations reform. As many of you know, the racial disparities for revocations for Native Americans are off the charts. We received feedback from the Northwest Indian Community Development Center in Bemidji, and they have laid out a path to community corrections that stresses local accountability. But they need the resources that are currently going to warehousing people and churning them in and out of the system. As this bill states, revocation should only be used as a last resort. This is not a partisan issue. 30 states have already passed technical violations reform. The red state of South Carolina has become a model in the use of administrative sanctions in lieu of imprisonment. Minnesota is no longer seen as a state on the cutting edge of criminal justice innovation. At a previous House hearing, the question came up, how many people are revoked to prison for one technical violation? Courtesy of the Rabina Institute, we have some data from Ramsey County. Is it common? No. Does it happen? Yes. In a 2-year period, 75 people were revoked for one technical violation, comprising about 20% of the total number of revocations. So this is not a cosmetic bill. It will have an impact. We'd like to thank Representative Hollins and Senator Chamberlain, the author in the Senate, for putting forth this bill. Representative Hollins met with people impacted and heard their stories. We met with Senator Roger Chamberlain in his office before the pandemic, and we were deeply impressed with his knowledge and his compassion. As he explained, there are limits to what government should and can do. There's nothing conservative about mass incarceration. Sometimes less is more. We also want to thank Catherine Johnson for testifying and helping craft this bill. I've got a report hot off the presses from Hennepin County, and it's a survey of people on probation, and they found that 90% of participants described their experience with their probation officers as respectful, fair, and humanizing. I think those are fantastic statistics. But they live with that stress of being revoked, and I think there's more we can do to make sure those revocations for non-crimes don't happen. Thank you very much.
All right, thank you very much, Mr. Cooley. And Vice Chair Moeller has handed me the gavel back. I had to get the kids out the door to school. And with that, it looks like we've got a couple people also available for questions, but we'll move on to member discussion. Representative Liebling.
Thank you, Madam Chair, and thank you very much to the testifiers and Representative Hollins for bringing this bill. I really like this idea, and it just, as a long ago criminal defense practitioner, I've seen this happen. And I've also seen that oftentimes some of the conditions that are put on people for probation are just really seem very unreasonable too. The one question I have, though, and maybe you can answer this from your experience in other states, but is there a concern that when judges know that they can't revoke someone on a first technical violation, that they might do the initial sentence more harshly in some cases, that they might actually incarcerate someone when they're kind of on the fence of letting them have a chance at probation, if they know that they won't be able to incarcerate them on the first offense? I hope that wouldn't happen, but and second part of the question would be, is there going to be a way that we would track this just to see what the impact or all the impacts? Will we be able to get some see how the policy is working if we're able to do this? Thank you.
Representative Hollins, or I don't know if one of your testifiers, looks like Mr. Cooley just took himself off mute. So Mr. Cooley.
Yeah, I can go. So the Pew Research has done the study on different states, and what they've seen is a massive drop in the number of people incarcerated. And so it hasn't, and we very much think about these unintended consequences. They haven't seen it. It's that turn that's really happening in Minnesota that's unnecessary. I mean, those folks we talked about in Bemidji, for instance, who are, and this is where those racial disparities come in, who are driving women to Shakopee, who are there for a very short time and then returned to Bemidji. I think we can cut down on that, and other states have shown that it is happening. And the other thing, of course, yes, we can track it because we can see what prison admissions are done on violations. And as I said, 65% in 2017, right? 2 out of 3 people are in for supervision violations. We got to do better. So yes, we can track it.
Any follow-up, Representative Liebling?
No, that's all. Thank you so much for that answer.
All right, thank you. Next, I have Representative Robbins.
Thank you, Madam Chair, and thank you, Representative Hollins, for bringing this bill. I generally support what you are trying to do. I think this is very important, but I do have a couple of questions. First, my understanding is that currently probation officers don't automatically have to remand for a violation. They could just write a report and note a violation. So could you address how this intersects with how it's currently handled?
Representative Hollins.
Yes, thank you, Representative Robbins. That's a really good question. And I'll be honest, it took me a while to parse through that and understand it as well. I think what I'll do is turn it over to Ms. Johnson from MACAC to give a more thorough explanation.
Thank you.
Ms. Johnson.
Thank you, Madam Chair. Representative Robbins, I think the best answer to your question is, in a lot of cases, you're correct. I think the goal of our probation officers, and I said this.
I can't hear her.
Can you hear me?
I can hear you.
Okay.
Yep, we're good. Go ahead, Ms.
I'm back.
Okay, sorry. So I think what you heard in my testimony was reference to that most of our POs, and it is generally how our POs work, how our probation officers work, is to work with clients to work through mistakes, to work toward behavior change. And that most often occurs as a result of the PO meeting with the client and saying, hey, you were supposed to be at this place. You were supposed to report for treatment. You were not supposed to have a dirty UA. And talking through cognitive behavioral interventions to get to the root of where those problems are coming from. And so, yes, most often our POs do not write formal violation reports for a first violation of one of those technical violations. That's not to say it doesn't happen. And I think that's what we're seeking to ensure here, is that in those circumstances where a PO feels it's necessary to go to that formal violation report for a first violation in these kinds of circumstances, that we're asking them to really tell us what the public safety risk is here when we're talking about recommending a revocation in those circumstances.
Follow-up, Representative Robbins.
Thank you, Madam Chair. And that is helpful, but it seems to me like this is just a comment, but that the flexibility is already built in there. If most of them don't do it already, but yet the numbers from your testimony were so off the charts that people are committed. I don't know, I'm struggling with that, but I really want to get to my second question, so I'll move on. So it seems like this applies across the board to every kind of underlying crime. And my concern representing my district is we have had some level 3 sex offenders in our district where there have been violations of some of these basic guidelines, particularly failure in number 8 to contact their law enforcement agent. And because my understanding of how the level sex offender stuff works is that if you get a level 3 designation, that means you do present a risk to public safety as sort of outlined in line 4.23 of the bill. So I'm just wondering if there's any acknowledgement that there are some underlying crimes where some of these, especially then failing to contact law enforcement at the proper time, kind of already, those two things already show a risk to public safety. And it just seems like a little bit strong to say that the court could never say that for the violation of this, in that instance, they couldn't go back. So if you could just comment on that or talk about why there's no designation of different levels of crimes.
Ms. Johnson.
Thank you, Madam Chair. I'll rely a little bit on my prior experience in my effort to respond to that question. I worked with the Minneapolis Police Department for 22 years before I became the Director of Community Corrections in Hennepin County, leaving there as an inspector when I left to take on the role in Hennepin County. And what I hear you referring to suggests to me that you're referring to a failure to register as a predatory offender, which is in fact a new crime. And so in my opinion, that would not fall in what we have outlined in the language of the bill. So that would itself, the failure to register would be a new offense, if I'm understanding you correctly.
Representative Robbins.
I'm sorry. So I was trying, I appreciate that, and that's an important thing. But in my case, in my district, where we've had, they failed to report contact with law enforcement officers, for a stop, a curfew violation, being seen near a park, that kind of thing. So that is the number 8 criteria in this bill. And that's the concern I'm trying to get at. And I'm sorry, I'm not very articulate in this legal area, so forgive me, but I appreciate your patience.
Any follow-up, Representative Johnson, or Ms. Johnson?
Thank you, Madam Chair. And I think in that circumstance, Representative Robbins, you also made the point that there is some clear public safety risk that is aligned with someone who is classified as a level 3 predatory offender. And so I think that would absolutely play a role in those reports to the bench or to the judge in requesting a violation or a revocation.
But it could be immediate. I'm sorry, Madam Chair.
Yeah, Representative Robbins, and then I understand one of our House researchers may be able to lend a hand in helping to explain this better. So I'm going to go to, I think, Mr. Johnson from House Research.
Madam Chair, Ben Johnson with House Research. Madam Chair, Representative Robbins and members, I think it gets a little complicated because we're talking about 2 different types of supervision, which can look very similar in practice, but also have very significant differences. One is what we would call probation, and the other is what is typically supervised release, but could also be conditional release or parole or other release from prison. If a person is on probation, then that sentence has to go back in front of the judge for any determination. And so when you're looking at the bill, the provisions that are in Section 4 of the bill relate to probation because it goes back in front of the judge to make those determinations. And the limitations in there apply to the judge revoking probation. When a person is a level 3 sex offender, that by definition means that they have already been to prison. They can't get that designation without having been to prison. Once a person has been to prison and gets out on typically supervised release or conditional release, then that sentence is not in the control of the courts any longer. It's in the control of the Department of Corrections. Any violations would go back in front of the Department of Corrections. The bill in sections 1 and 2 would, it's very fact specific, of course, but if an agent believed that a person was violating any of those listed conditions and was a risk to public safety, which seems to be what you're suggesting, that agent could arrange for the person to be taken into custody immediately. And at that point, that would go back in front of the Department of Corrections. And the limitations on revocation that appear in Section 4 of the bill would not apply to revocations for supervised release or conditional release or parole. So they would not apply to the Department of Corrections. So in summary, I've talked a long time, but in summary, if somebody's a level 3 sex offender, those limitations on revocation that are in Section 4 would not directly apply to those people. I hope that's clear.
Thank you. Very
Mr.
helpful.
Johnson, Mr. Johnson, you talked a long time, but that was very long time for an answer, but it was an answer that required a little more information. So thank you very much. Representative Robbins, do you have any follow-up?
I'm all set. Thank you very much.
Okay. And then I see Midge Christensen also has her hand up. She was one of the potential testifiers on deck. So if you could introduce yourself and then go ahead with your response regarding that topic.
Yes, thank you, Madam Chair. My name is Midge Christensen. I'm the director of 6 West Community Corrections. So we have 4 counties, Chippewa, Lac Pearl, Swift, and Yellow Medicine in western Minnesota. And one thing I just wanted to clarify as well is that this bill is dealing with first-time violations of the enumerated technicals. And so Mr. Cooley referred to some statistics for folks being revoked to prison on technical violations. That figure encompasses not just first time, but people who are also revoked because of numerous technical violations. So this bill is talking about the first time someone does one of these technical violations. And it does have the provision that allows, if there is a concern about public safety that can be articulated, that the court can take that into consideration. Thank you.
All right, thank you. Going to move on to Representative Johnson.
Chair Becker-Finn, members, I'm just wondering, looking at this, I understand the premise of this bill. I've talked to many probation officers, and none of them have ever revoked somebody on first offense. They have brought them in before requested they come in before the judge on first offense because of the seriousness of the issue. But there's some other concerns I have with this bill. I'm just wondering, because the way it's written, maybe Ms. Johnson can answer this question. Because it's going to have to document, and for first time of any type of offense now, normally the probation officer documents, puts in his report, keeps track of any and all violations. I'm just wondering now if for any time there is a violation, that instead of just documented, keep it in their records, they're going to have to turn over all and any violations to the court system so they have a record of it there, or it's going to be the same way it is now, where the probation officer keeps track of the violations and the number of violations, and at some point, if they continue, bring the person back into the courts.
Not sure who wants to respond to that one. Ms. Johnson.
Thank you, Madam Chair. Representative Johnson, I would anticipate that from the perspective of how the agents are doing their work and their reports, that will remain the same. The fact that there are not formal violation reports filed most often with a first violation is something that we, in my perspective, would expect our agents to continue with. I don't see a need to create more violations in order to address the potential that a future violation would result in a request for revocation of sentence. I think agents do document those violations. They document them as you suggested in their narrative reports. And I don't anticipate that would change.
Representative Johnson.
Chair Becker-Finn, Ms. Johnson, I thought that's what it was going to be. Otherwise, if they had to do put in reports every time there's a violation, I think there would be a fiscal note in the court system for all the extra work they're going to have to do. That part's not an issue. I do have a couple other concerns on this bill, especially when there's somebody that's that could be a serious risk to the public safety. Because they cannot, the way this bill is written, they cannot take them into custody and bring them to the courts. They actually have to go to the courts and get a warrant. That's in 4.18 to 4.25. I have concerns there. Also, the bill also states that the courts may not direct. I think there's a separation of powers issue. We cannot tell the courts what to do. In fact, we have a bill that we've heard in this committee dealing with, trying to remember what it was now, dealing with pre-sentence investigations, where our law says there shall be one, but the court rules is there may. And a lot of judges are following the court rules because we cannot tell the courts what to do. And now we're directing the courts that they cannot do something. So I think those are issues that need to be worked on. At this time, I am supporting this, but I say it still needs a little bit of work.
All right, thank you, Representative Johnson. I will note that we can tell the courts what to do. That's actually exactly what we do when we make law, is we tell the courts what to do. Next on, I see Ms. Christensen has her hand up.
Yes, thank you, Madam Chair. I would just like to clarify as well that under statute 401.025, this bill, starting at line 1.24, does allow probation to still place someone in custody if they believe there is an immediate public safety risk, even if it is the first time occurrence. And so that is something that as practitioners, we were concerned about, and we worked with the author to make sure that that allowance was still there, because we do want to be able, in those situations that Ms. Johnson described, where it's a public safety matter in the middle of the night with a domestic situation or something like that, that we have the ability to still do that. So we're confident and comfortable with what the language says in the bill and the allowance for that at this time. Thank you.
Thank you for making that point. I think that's an important one. Representative Long.
Thank you, Madam Chair. I want to thank Representative Hollins for bringing this bill forward. I wanted to, I think, provide some information that might be helpful in response to Representative Robbins' question about what might change under this bill. I think that we've seen that presumptions matter for the way that probation officers are able to avoid revocations when at all possible. And we've had kind of a natural experiment with the pandemic and with a presumption that we don't want to send folks to prison when there's a risk of spreading disease. So in Ramsey County, they're tracking this right now, as Mr. Cooley mentioned, and I think the report is due out in a couple of months. But they have found that when there's a presumption that you don't want to send somebody to prison, in this case because of the pandemic, in Representative Hollins' case because of the bill, that you can avoid that in a lot of circumstances, and you can work to try to find different outcomes. And there has been a real drop in revocations in Ramsey County. They've tracked as a result. So I think that, trying to at least put in the mind of the officers, who are working with folks under supervision, the presumption that they should keep trying to work on rehabilitation when at all possible, that will matter for a lot of circumstances. And we still have seen in Ramsey County, that there were first-time revocations for first offenses. So I think having these presumptions will make an impact. And I just wanted to note for for Ms. Johnson and Ms. Christensen and others, that I do think it's really powerful to have practitioners coming forward and saying that this is what you want and that this is something that you think would be meaningful for your profession and for trying to move this forward. So I appreciate your hard work on this bill. And thanks, Representative Hollins, for bringing it forward.
All right, and Vice Chair Moeller.
Thank you, Madam Chair, and thank you, Representative Hollins. And I, too, just wanted to provide a little more clarity also, because when we talk about technical violations, people have different definitions for what that is. And some folks refer to technical violations as anything that's not another crime, whereas others consider it more of like minor violations, like not, checking in with somebody. For example, if there's like a no contact order in place, and somebody violates that, I wouldn't consider that technical. I would consider that important, and that can still be brought as a factor here. That's not something that's in this bill, which I really appreciate. There are many, many guardrails here, and that's why I support this bill. I think it's a good bill. Thank you.
All right, thank you, Vice Chair Moeller. And with that, any closing comments, Representative Hollins?
I just really want to thank, thank you, Madam Chair, and I want to thank the committee members for hearing this. And I really want to thank my testifiers and MACAC, Decarcerate Minnesota, and a special thanks to Ben Johnson from House Research, who has waded through this really deep and really hard with us. And I just so appreciate all of his assistance with it. And with that, I would urge you to encourage this. I think this is a great bill. It strikes a really nice balance. It's very moderate, and I think it will have a great impact on the people of Minnesota. Thank you.
All right, thank you. Representative Hollins renews her motion that House File 1761 be recommended to be placed on the general register. The clerk will take the roll.
Chair Becker-Finn.
Aye.
Representative Moeller.
Aye.
Representative Scott. Representative Feist.
Aye.
Representative Frazier.
Aye.
Representative Grossell. Representative Grossell. Representative Hurd.
Aye.
Representative Hollins.
Aye.
Representative Johnson.
Aye.
Representative Liebling. Representative Liebling.
Aye.
Representative Liebling, aye. Representative Long.
Aye.
Representative Mortensen.
Aye.
Representative Novotny.
Aye.
Representative Farr.
Aye.
Representative Robbins.
Aye.
Representative Vang. Representative Vang. Representative Zhang.
Aye.
Representative Grossell.
Aye.
Representative Vang. Okay, I have 15 ayes and no nays.
All right, thank you. With that, the motion prevails, and House File 1761 is on its way to the general register. That wraps up our agenda for the day. Representative Johnson, I see your hand up. Go ahead.
Chair Becker-Finn, as we're finishing up today and finishing up the week after deadline week, I'm just wondering when we'd be able to expect the DE for the budget. So when it's going to be available, so we can start having a look at it and going through it.
Thank you. Representative Johnson was going to address that before we wrapped up today. I hope to have that to folks early next week, and that we're still working on it. We just got the targets a couple days ago, so we'll definitely get that out to folks as soon as we are able. And yeah, I hope that everybody has a really good week off. I know that most of us will still be working, but at least we won't be on Zoom, hopefully 12 hours a day. So would just thank the committee for all the work up to this point. We've heard a lot of bills, even more than I thought we would be able to fit into our committee time. And really appreciate the work, especially of all of our staff, nonpartisan staff, as well as the committee staff in making sure that we run smoothly, especially with some of the extra times we've had to meet. And recognize we often get those emails long after 10 p.m. with our information about our upcoming hearings. So I do want to thank all the staff for that and wish everybody a good week away from Zoom and away from committee work for a little bit. So yeah, as I said, we will post that as soon as it's available. And with that, we are adjourned.